My name is Paul O'Rourke. We're back with another session of Perspectives with Paul. Today we're talking about Miranda Rights. A lot of times I get a client that comes in and they'll say, they didn't read me my rights. They never told me what I was under arrest for. And when they're talking about that, they're talking about the same thing they've seen in the movies 100 times, which is the Miranda Rights. The Miranda Rights are the rights that the Supreme Court has said that if a police officer is interrogating you in custody that they need to make you aware of. And that's the one you see on TV. That's you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you can't afford one, one will be appointed for you. And there is a fifth element that should be used by, and it is used by, I think, the federal agencies, which is understanding that you have the right to stop answering my questions at any time, should you decide to speak with me. When they talk about they didn't read my rights, there's almost an expectation that if they didn't read you their rights, then the case should just go away. And that is partially true and partially not true. The fact is they don't have to read your rights if those two parts of the equation, what's called the Miranda equation, aren't present. And the two parts are in custody, okay, and that can mean several different things, from having handcuffs on to just not feeling like you'd be free to move. There's some criteria. And so you're in custody and then interrogation or interviewing, okay? And so what will happen is if you don't have both those elements, they don't need to read you your Miranda rights. And even if they do, even if both those elements are present, and they don't read your Miranda rights, then the remedy or the result of that would be that the court would find that, and then they might suppress the statements made. That would be it. And so it may not be the end of the case if there's other evidence that would demonstrate that somebody is guilty or not. So not reading the rights is not a fatal mistake by police officers. What can be a detrimental mistake by my clients, though, is when they speak to an officer without an attorney. And how I see that usually happening is the officers understand the way this works, and so what they'll do is they'll do what's called a non-custodial interrogation. And what they do is they invite you to the police office or to the police station and have you come down to the station to speak with them. And they might do it on the phone. They might just say, hey, we just want to get your side, or we've got the other party's side, what's your side of the story? We want to get both sides on the story and let the prosecutor decide. Well, that may be the case, and if that truly is the case, when you say to them, well, I'd like to speak to an attorney before I speak to you, they're not going to have a problem. But if they say something like, well, if you're not guilty, you don't need to speak with an attorney, that's just not true. The reality is there are a lot of innocent people that have their words twisted and find themselves in a legal battle, which will cost them time, energy, and money. So it's worth a little bit of money beforehand speaking with an attorney to find out whether you should. And maybe you do need to have an attorney there so that your words aren't twisted, or that you don't answer something that might be detrimental to you. You have the right to remain silent. That is probably the most valuable piece of defense that you can have. In other words, they may have everything they need without you making a statement. They may not. But you remaining silent is not something that they can use against you in a court of law. But anything you say, they can and will use against you. You have the right to an attorney. If you don't use one, you're waiving those rights. And so if you find yourself in police custody, even if in police presence, and they're asking you questions other than what your name and date of birth is, then your answer should be, I don't wish to answer any of your questions, and I want my attorney present. You can't say it kind of, or I think I might, or maybe I need an attorney. You have to say it emphatically, directly. I want an attorney present. Because if you don't, you're not invoking those rights, or I'm not going to make any statements. And then you start talking, you're considered waiving those rights. And once you waive those rights, it's very difficult to show that you weren't consciously waiving the rights, especially if you've been read Miranda. And as a side note, going back, if you're on the phone, you're certainly not in custody, so any kind of information you give won't be considered a Miranda violation by the officers. So my advice to you at this point, anyone, is before you speak to the police or law enforcement, you need to speak to an attorney to find out what kind of potential hazards there is in speaking with law enforcement. And that's a short blurb on Miranda. If you have any questions or like what you're hearing or any suggestions, please leave them in the comment section below, and like us on Facebook and follow us on our channel. Subscribe to the channel. Thank you.